Due diligence, if done properly, which means taking a risk-based approach, will not only help companies satisfy their compliance requirements, but it'll also offer them a really powerful tool in getting to grips with the potential corruption exposure that they might have with potential partners or in upcoming deals. A lot of companies initially saw the FCPA and the UK Bribery Act as imposing a costly burden on them and would really apply a tick-the-box approach, a very standardized approach to due diligence. But the FCPA and the UK Bribery Act are explicit, and they really point to the fact that companies need to take a risk-based approach, which means assessing the depth and the level of due diligence that's appropriate for their deal and for the type of partners that they're dealing with. Most of our clients have reached the stage where their anti-bribery and corruption policy does include due diligence procedures. The problem, which was highlighted in our recent survey, is really around follow-through. And that applies to training, but particularly to due diligence. Third-party due diligence is often overlooked, which means that companies aren't applying third-party due diligence as a matter of course like they should. This is really a critical gap, and it's fairly widespread. 62% of respondents said they still didn't have a third-party due diligence procedure in place at all. In the M&A context, there's an increasing appreciation by lawyers, both in-house counsel and external counsel, as well as deal makers, of the value of focusing on corruption as part of the M&A due diligence. In 27% of cases, companies have pulled out of M&A deals because they've identified corruption issues, having added a specific anti-corruption element to their M&A due diligence from the start. Doing this early on really stems off late-stage surprises. A lot of companies still have a way to go in this, particular corporates, but we see some progress being made across the board in this respect. The bar for due diligence programs is really set by US companies. They've had over 40 years experience working under the FCPA. They've integrated due diligence programs into their strategic planning, and a lot of companies even price due diligence into their deals. We are seeing signs of progress elsewhere. If we look at the 2006 survey we carried out, as opposed to this year's, we're seeing a significant increase in respondents from the UK, from France, and from Germany who have due diligence programs in place. There needs to be a tighter focus on third-party risk, though. The OECD in 2014 released its own analysis of 400 corruption cases, and 3/4 of those involved third-party corruption. If we take that third-party risk into account, there's a difference between a due diligence program and an efficient due diligence program that's targeted and focused on where the real risks lie. We're discussing compliance due diligence. So looking at what's appropriate due diligence really needs to take into account two significant factors, and that's the breadth and the depth of the exercise. The breadth of an investigation is really the subjects, entities, or individuals that will be looked at in a due diligence investigation. The questions that need to be asked are, will everyone be covered? Will all entities be included, or only the most significant? And what do we mean by the most significant? Are we talking about the largest shareholders or the ones with the highest corruption risk for other reasons, for external factors? The depth really looks at the degree of rigor that we're applying. There's a big spectrum, anywhere from a Google search, as well as cross-checking names against sanctions list, to a much more thorough and in-depth approach, including interviews with people who have had dealings with the company or the people in the past, and lifting the corporate veil to look at ultimate beneficial owners. That takes us to a level of due diligence which can really expose information that will be key not only in meeting compliance regulations, again, but providing real value to a company to understand what they're getting into. A contextually aligned and intelligence-led due diligence program is an incredibly powerful tool for companies. Firstly, it allows them to have a risk-ranked database of all of their third parties. That means traceable information should they ever have to deal with a regulator, and also the risk-based approach means that they can apply the correct depth of due diligence to each of those third parties. In an M&A context, this will allow companies to identify corruption risks early on in the deal, which might have an impact on the value of that transaction, but also allow them to put the right resources in place to mitigate or manage any of those risks in the post-transaction phase. But a due diligence program of this nature is only effective if it's dynamic, reviewed regularly, and actively used by the right stakeholders in a company. In recent years, many companies have reverted to a standardized one-size-fits-all approach to due diligence. At Control Risks, we believe it's time to refocus on contextually aligned and intelligence-led due diligence, whether that's looking at third parties or in the M&A context.